Hello people, welcome back to my YouTube channel. I'm super excited to have you watching this video. In today's video, I'll be sharing with you what you need to do when served with divorce petition, or let's say with divorce papers. What do you need to do? To start with, it can be very overwhelming when you find yourself in a situation like that, but I want to encourage you that you've got this and you can actually scale through. It is possible for you to actually try to mediate. It is as well possible for you to say you want to actually go ahead with the process. So in this video, I want you to sit back and watch this video till the end, as I will be sharing with you helpful tips if you find yourself in a situation like that. By the way, my name is Mary. I'm a practicing lawyer in Nigeria, and on this channel I share videos to educate the general public. Okay, so to start with, what do you need to do when served with a divorce petition, or people also call it divorce papers? What do you need to do? The first thing you need to do is that you need to write the date and the time when you were served those papers. For example, if somebody walk up to you or probably call you like, oh, madam or mister, we have a process to serve on you. When you collect those process, just note on the document the date and the time that those processes have been served on you. Okay, so that is the first thing. The second thing is you may try to mediate. If you still want to work on your marriage, even if your partner is saying, oh no, I don't want all of those things, you can always try mediation. Because when we talk about mediation, it is not just you or your family member. It could be the lawyers, that is the lawyers, his own lawyer or her own lawyer can as well mediate, and good thing can actually come that way, because since the his legal representative or her legal representative will also talk to him about it. Okay, so it is possible for you to do that, but do not forget the first thing is to write on those documents, on those papers, the date and the time. Okay, so the second thing is mediation. Because I realized that oftentimes, even the people that say, oh, I am even done with this marriage, I want to go ahead with it, they still find it overwhelming. So it is important for you to try mediation first, because truthfully, divorce can actually be very overwhelming. When it even involves children or properties, a lot of back and forth most likely will happen in court, because we court such cases contentious cases, that there are other things apart from the dissolution of the marriage. There are other things that the parties actually need to decide or need to actually argue out in court. And stuff like that will definitely be overwhelming, because the person you're in court with is actually one time someone you loved, or probably you still love the person. Okay, so the first thing, write the date and the time. The second thing, try mediation. Mediation could be within the families, it could be just you and the person, it could be your legal representative and our legal representative coming together, sitting with you people and actually trying to mediate. In some courts, that is one I've seen. I don't know about high court. In some customary courts, you see the judges also trying to talk to parties to actually reconcile their differences. I often share in my videos that the Nigerian law actually protect the sanctity of marriage. That is, you can't get married today and the next day you're not finding it easy and you want to walk away. So the courts will not force two people to be together. I do say that no law will force two people to be together. If one party is unwilling, the court will definitely, if you can prove what it is required by you, the court will definitely dissolve such marriage. However, the court as well, before you get to that stage, the court always try to mediate. So mediation is a very good thing. If you can put down your guards, if you can allow your ego or the pride to actually go down, it is possible for you to try mediation. So the third thing is have a support system. This is very important. Probably because I have handled a lot of divorce cases, I see people, like I mentioned earlier, even the ones that are like, oh, I'm done, I don't just need this marriage again, they still find it overwhelming. Some of them still find it overwhelming. So for you to have a support system, that is somebody, a shoulder you can lean on, someone you can always talk to, someone who you can share your secret with, who can always keep it. So you need someone that that will give you a listening ear, that you can cry to. You just need someone who can support you during that period. That person could as well be the one to go with you to the court. Please, when I talk about support system does not mean your child, except if that child is an adult. And even if that child is an adult, I'm of the opinion that It shouldn't be that your children can support you if it's an adult, but it shouldn't be your child that will start going to the courts for court proceeding with you, because I feel in one way or the other, if you are the respondent, that is, if you are the other party, if you are the like the one who initiates a divorce proceeding is actually the petitioner, the other party is the respondent. So if you're the respondent and you're saying you need a support system and you want to start going to the courtroom with your child, in one way or the other, I feel your child may actually resent the other party, whether it's the father or the mother. So you can have a support system. It is possible for you to have your child as a support system if your child is an adult. I wouldn't advise that that's your support system, that your child should be the one going to the courtroom with you. Okay, so your support system, it will be better if it's maybe your parent. It will be better if maybe a good friend. You know, it could be a sister, your brother. It's better that way than you having your child as a support system. It's very, very wrong. I know a lot of people actually make this mistake and make their minor, somebody, a child, not up to 18, and you sit the child down and start saying things about the other party. That is very, very wrong. So do not forget, write the date and the time. 2, try mediation. 3, have a support system. The fourth thing is for you to have a legal practitioner, like a legal representative, someone who can represent you in court. Okay. It will be better if that person is somebody that is very vast in family law, like divorce, family law. It will be better because that person will be able to actually put your interest. Every lawyer can actually represent you. I'm only saying it's better if you have a family law lawyer, because the family lawyer would definitely have handled a lot of cases like yours, and it will help that person to be more effective in actually handling your case. At this stage, you can actually give those processes to your legal practitioner. The processes that were served on you, you can give them to your legal practitioner. You can as well make a photocopy and keep a copy with yourself and give the others to your legal practitioner. At this stage, you can talk to your lawyer that you want to try mediation. Okay, so your lawyer will be in court, announce his appearance, and inform the court that parties are willing to settle. Probably before mentioning that to the court, the lawyer must have talked to the other lawyer or your partner that, okay, can we settle this? So your lawyer will be your representative, even though you will be a part of the mediation, but your lawyer will be the representative, and they will form a court that, okay, we are trying settlement, and the court can give a longer date instead of giving probably 2 weeks or 1 month adjournment. The court can give like 2 months or 3 months adjournment to allow you people to go and reconcile your differences, and hopefully if it's favorable you can come back to the courtroom and tell the court that parties have actually reconciled. Okay, so that is the fourth stage. The fifth stage is for you to give all necessary facts to your lawyer. Necessary facts. If your partner is saying, okay, he or she is choosing divorce for so reason, you can give your lawyer the details about if that fact is actually true, if it's true in its entirety or in part, or probably it's false. You need to, you since you also have the process, you have the process was served on you, you have to go through the documents and start giving the facts of each of those paragraphs to your lawyer. It is if you find it overwhelming and you don't want to even go through the documents, you can just give your facts in general to the lawyer. The lawyer will definitely know how to actually reply to those each of the paragraphs in the petition. Other things you need to inform your lawyer is issues of custody and maintenance. If they are children of the marriage, you need to tell your lawyer if you want the custody of those children and the maintenance. Please note, probably you need to watch my video on custody. Oftentimes I see some parties mentioning to the lawyer or saying to the courtroom that they don't want custody to be, they don't want the other party to have custody at all. It is not possible. It is not, except if that person is probably mentally not stable, probably such reasons. But you can never deny your partner of custody of children of the marriage. The child still belongs to them, irrespective of probably the person is irresponsible, or whatsoever. So you need to tell your lawyer about the custody. It is possible for you to have custody, but the other party will have access to those children during weekends and holidays. Okay, so custody is very important. It cannot even, I don't even think it's reasonable for you to say you want to have custody all to yourself, because, for example, if you're the woman and you want the custody all to yourself, you will still allow you whatsoever that may be happening between you and your partner shouldn't affect the child, in the sense that they still need to have a father figure in their life. Probably you want to remarry or you feel your father would do that for them. It's still not enough, because oftentimes I see those children even resenting their mother, because no matter what is happening between you two, Oftentimes you see children wanting to know who their father is. So it is in a few cases that probably whatever the mother or that party must have informed the child. Probably the person may not care about knowing who the father is and all of those things, but it is important for you to allow the other party to have access to that child. And if the court make a pronouncement on that, like okay, the custody will be with the mother, but on weekends or probably with a reasonable notice, the other party can come to check up on the child or take the child out, and you are doing contrary to that, you can be that will be a contempt of court. So you cannot deny the other party. There is nothing you can do about it. You cannot deny the other party of custody or access to that child once in a while. So another thing is when we talk about custody, you talk about maintenance, tell the lawyer, okay, this is the school the child attend, the other party need to provide. Oftentimes, if the other party is the man, so oftentimes you see a lot of demands on the man, particularly if he's doing much more better. Okay, so and another thing is if there are properties of the marriage, you need to inform the lawyer that there are so properties that were acquired during the marriage. The marriage is still on anyway, but yeah, during the marriage. So you need to inform the lawyer, and the lawyer will definitely draft certain things probably for you to have some of those properties. Okay, so that is basically okay. The last thing I need to mention is that you need to start preparing for life after divorce. That sounds so scary, I know, but you need to start preparing for it in terms of you saving up. If the other party has been the one in charge of the accommodation, you need to start saving up to get your own accommodation. Oftentimes you see people even moving out when the divorce proceeding commence. So, but if that is not your case, but you need to start saving up. This is one mistake that I feel a lot of people make. You need to start saving up. You need to start preparing yourself mentally for it. If you're a woman, you need to start preparing yourself like now you are going to be a single mother, which is not it has no it doesn't have, for me, it's nothing negative, because if, for example, while you're working out on the marriage is probably domestic violence, so you being a single mother, is it not better than you? I'm not an advocate for divorce, I do say that, but I'm just saying if it's in an extreme case, whether extreme or not extreme, you have your reason to say you want to file for divorce. I'm sorry for the noise in the background. We're actually in the north, and oftentimes you hear a lot of prayer call. So initially I was trying to actually pen the video, but let me just continue. So basically that is just the last point. You need to start saving for accommodation, preparing yourself mentally for the new stage of your life. Okay, so you need to just prepare for that a lot. Take care of yourself so that when the marriage is being dissolved finally, it will not eat you so much. Okay, it will not eat you so much. So I hope this information educates you. If you have any question, do not hesitate to drop it in the comment section, and I will also have my email address in the description box. So if you have any question you don't want to drop in the comment section, you can always send that via my email. Thank you so much, and I will see you in another video.